Hello, my name is Richard Barid, and I'm an elder law attorney here with Smith Barid LLC. Thank you for joining me today. Today we're going to talk about a question we get frequently, which is how can we protect our assets, or mom and dad's assets, from Medicaid, from the state coming in and taking everything. One of the questions we get most frequently is, how do I avoid having my house taken by Medicaid? Or for the kids, the grown-up kids, it may be, how do we protect mom's house or dad's house from Medicaid? They're going to need to go into a nursing home soon. Medicaid is going to be a big payer of the cost. How are we going to avoid losing the home? Because we know Medicaid comes in and takes the home. Well, in certain ways, that's kind of a misconception. What happens is, in order to be eligible for Medicaid care, using Medicaid to pay for what you can't pay for your long-term care, you have to be financially eligible. That means there are asset requirements and there are income requirements. The asset requirements are basically that a person not have more than $2,000 in their name, $2,000 in countable resources. A spouse at this point can have a little over $137,000 in assets in their name, but that's it. Anything more than that, and the person who needs Medicaid will not be financially eligible for Medicaid. So what happens in cases where people's home is taken, what really happens is, if they're otherwise eligible, but they have equity in their home, having a home that you own, even when you go into a nursing home, will not block your eligibility for Medicaid. It won't impede that eligibility. But what will happen is, when Medicaid is approved, Medicaid will be keeping a running tally of everything they spend on your behalf or on behalf of your parent, whoever needs Medicaid, and they'll be keeping that tally for the purpose of estate recovery. And what that means is, when the person who needs Medicaid passes away, when they no longer need Medicaid, and if the spouse has passed away as well, if there's no surviving spouse, or that spouse has passed on recently, passed on at any point after the person needing Medicaid care is using their Medicaid care, and Medicaid will put a lien on that house, and if the family doesn't pay the lien, they can ultimately foreclose on that lien, just the way a mortgage holder would. Sometimes the state is patient, especially if there's a mortgage ahead of them, so to speak, meaning there was already a mortgage when Medicaid placed their lien. That's up to the state what they decide to do with that. So while Medicaid will not come in, and neither will the nursing home, and simply take mom and dad's home, they will be keeping that running tally, which they plan to collect from any equity in the home when the family goes to retitle or sell or refinance the home. So it's not the result that most people want, and there are ways to protect assets. There are assets that are accountable, like cash, checking account, savings account, money market, CD, investments that are not part of a 401k or an IRA. Those are assets that are worth protecting as well. And with that very small asset limit, the $2,000 asset limit, it's critical that we do that the right way. And there are strategies that can be used. We have pre-planning strategies, which means strategies that are put in place 5 years or more before a person needs Medicaid. And in those cases, we can often salvage 100% of the assets. But if a person waits, as many people do, you know how it is, you have a busy life. If you're caring for a spouse or a parent or any loved one, you know how exhausting it is to be a caregiver. And so that's where your energy is going, and not necessarily to Medicaid planning, because you don't think of it, or because you're too busy, or because you've talked to somebody about it but you believe it's too expensive. There are many reasons the planning doesn't get done 5 years ahead of time. At that point, we call it crisis planning. What that means is, if a person needs Medicaid within 30 days of the time the family comes to see us, really almost any time under 5 years, but especially we see a lot of folks who within 30 days or even immediately have a parent or a loved one who needs to go into a nursing home, and they're going to need help paying for that care. That's called crisis planning. There is still things we can do. Don't let people tell you there's nothing that can be done. There are things that can be done, but we're generally, not always, but generally talking about being able to save somewhere from 40 to 60% of the assets at that point, instead of the 100% that we can save if someone comes in and does advanced planning with us 5 years or more before the time a person needs Medicaid assistance. So I hope this has been helpful to understand a little bit about the paths forward if you have a loved one who needs care or will need care. And I would encourage you to check out your options, talk to us, give us a call, look at our website, and get familiar with the pre-planning resources and the pre-planning strategies that are available with the right elder law attorney to help you. You'll find that most attorneys don't practice in this area. They consider it too esoteric or too complicated, or they're just busy practicing in other areas. This is one area on which we focus our time and our energy and our continuing education, is to be able to help families with just this sort of issue. So find a qualified qualified elder law attorney, give us a call and we can talk you through the differences and the different type of planning available and hopefully find a pre-planning solution for you that will result in protection of 100% of your assets or your loved one's assets in the event Medicaid is needed. Thanks for stopping by and check back with us for more useful video content anytime you'd like.